Hi, everyone. My name is Beverly Allen. I'm a Tacoma-based attorney, and this video I'll be talking about revisions and reconsiderations, which are available avenues for you before the Superior Court if you are unhappy with a decision of either the commissioner or of the judge. So before we get into that, just a little disclaimer. My opinions are my own. They're based on my experience, but they're not endorsements by the Pierce County Law Library or by Pierce County. With that said, I have a PowerPoint to share with you all. Okay. So when you are not happy with a Superior Court decision, you have a couple of options. A reconsideration means that you are asking the same judicial officer who originally made the decision to change their mind. And so an issue that can come up is if, for example, you were in front of a pro tem, meaning a substitute commissioner, and you are unhappy with that commissioner's decision. If that's the case, you will have to work with the Commissioner Services Department to make sure that you are scheduling your motion for reconsideration when that person is next on the bench. Because if you're in front of a different commissioner, they are not going to address a reconsideration because they were not the commissioner that originally made that decision. So that can be a problem. A revision is when you are asking the higher level of the court, so the judge, to make a different decision than what the commissioner made. On a revision, that is what's called a de novo standard of review, meaning that the Superior Court judge is not required to do the same thing the commissioner did. In fact, they're not even required to give the commissioner's decision any sort of weight. They can make a brand new decision, brand new criteria, but the only caveat is it's based on the same facts that were before the commissioner. So it's not your opportunity to file new evidence. If there was new evidence that just came to your attention, such as, for example, a police report that was just made available to you, you should try reconsideration. In that case, you can get that in front of the same judicial officer. And if you still have a problem, then you're filing a revision based on that decision on reconsideration. And then you can have the judge consider your new evidence. A route appeal is also before the Superior Court. That is when you are appealing an OAH decision, which I talked about in another video, to the Superior Court judge. And you're asking them to make a different decision than what the Office of Administrative Hearings did. There are some other avenues to get relief if you have blown your deadlines for filing appeal or filing revision or reconsideration. You can still get some relief by doing a motion to vacate, perhaps, or to clarify or to enforce. Alternatively, you can invite the other side to do a mediation, and you can see if you can come up with some agreements that address your concerns. The motion to vacate is governed by Civil Rule 60. That's found at www.courts.wa.gov/rules. You're going to click on the rules for Superior Court, and you will click on Civil Rules. And that's where you will find the rules on reconsideration and revision. But the motion to vacate in most circumstances needs to be filed within 1 year. And in any event, should be filed in a reasonable time. So motion to vacate is where you're saying, Your Honor, I'm asking you to completely undo, reverse, get rid of this decision to vacate it, to make it go away, and to do something else. The grounds for that are laid out in Civil Rule 60, but again, most of those ways of acting, so for example, if you are claiming that there's been a mistake, if you are claiming that there's an error in the wording of the order, those need to be filed within 1 year. So the actual deadline, the first deadline, is to file that notice of revision or reconsideration. That needs to be filed within 10 days, and that's found in Civil Rule 59, also the Pierce County local rules. The decision needs to be heard within 30 days unless there is good cause. Good cause might be there's some holidays, it might be there's some other reason why you're unavailable, but you can go ahead and get permission to have the actual hearing outside of that 30-day window if you have good cause. Appeals. Appeals are going to be the subject of a different video, but there is a deadline at the Superior Court level that you need to be aware of, and that is filing your notice of appeal. That is a document filed in the Superior Court that starts the gears rolling for that appellate court action, which is filed before the Court of Appeals. And for Pierce County, that's Court of Appeals Division 2. Again, that's the subject of a later video. So what are the legal standards? Well, I've already talked about the rules. You find those in Civil Rule 59 for reconsideration or revision. But the reality is reconsiderations are not usually guaranteed to get you a different result. They're very difficult. I've had them successfully granted. Sometimes when it's clear that the commissioner made a mistake, and without getting into the case details, I had a motion for reconsideration granted at the very end of the docket, which I believe was because the commissioner knew that they were going to change their mind and wanted the rest of the docket to be heard before they made that decision, saying, I made a mistake. It's rare that they do make the kind of mistake that is apparent and needs to be reversed. So that's a reconsideration. Again, that's the same judicial officer. Now, if you have brand new evidence, such as a brand new CPS report, a brand new police report, or a criminal charge that wasn't available to you before, you will have better luck probably. If it supports your argument, you might get a reconsideration granted. Revision. As I've said before, that's a de novo review, but here's the key. All of the pleadings that were in front of the commissioner need to be filed as working copies to the judge. That includes not only what you filed, but also what the other side filed. And I'm speaking from experience. As a younger attorney, I almost had court deny me relief because I didn't file every single pleading before the court. So make sure that you don't make that same mistake. File everything as a working copy. And you can see that in links. A separate video, by the way, available on the Pierce County Law Library website. I show you how to sign up for links. Please, please do this. It will make your life so much easier as you're engaging with the Superior Court. So I've already said that an appeal notice is filed at the Superior Court. There's a few standards to be aware of. If you are saying that the Superior Court made a bad decision about what the law means, that is de novo, meaning that the Court of Appeals doesn't have to give any weight or discretion to what the Superior Court did. But if you are asking the Court of Appeals to reach a different decision about the evidence and what the evidence means, then that's entitled to some discretion, some weight. That standard is called the abuse of discretion standard, and you have to show why the judge's decision was not reasonable given the facts and evidence and given the law. So I've already said this, but the Superior Court decisions are governed by the civil rules. Those are found at CR 59 and 60. The appeals rules are found somewhere else. It's the rules of appellate procedure, but it's the same website, which is courts.wa.gov. Now, there are plenty of resources out there for you. First and foremost, read the local rules. Motions before judges are governed by Pierce County Local Rule 7. The family law proceedings are special proceedings. I believe it's Pierce County Special Proceedings Rule 93.05 is where I have most of my rules that apply, but go ahead and read all of the rules that apply to you. Civil rules are found at courts.wa.gov. Same thing with the rules of appellate procedure. For research, you can go to the Pierce County Law Library, to the official website, and look at their research tools. They have NOLO, they have Casemaker. You can access those for free, but you have to go to the Pierce County Law Library website to get the login information. Also, Google Scholar Courts does have the ability to do legal research. You can select Washington, and you can go ahead and look for search terms and find cases that seem to apply. You'll have to do a lot of reading when you're doing revision or reconsideration, and especially when you're doing an appeal. So when you are challenging rulings, you need to file a note for motion that gets your hearing scheduled. You also need to file the motion, and you need to make sure that you serve the other side and do working copies for the court. The working copies is a button in links. That's another reason to sign up for links. Service, though, is either done by mailing the motion or by personal service, which is where you have someone deliver it, or if they've signed up for a links account and have consented to service by electronic means, you can also email that. You also have to provide proof, which is done by filing a proof of mailing with the court. That explains how you gave notice to the other side about your motion for revision or reconsideration. And again, I've already gone over this, but if you've missed all of your deadlines, consider a motion to vacate or consider another type of motion such as to clarify or to enforce. What motion you file is going to be fact specific, so make sure that you're doing what makes the most sense for your case. Drafting tips: before you sit down to write, have a clear idea of what you're asking the court to do and why. Make sure that you've read the local rules, make sure that you've done your research. And then once you have gotten to court, you'll be before the court on either a Zoom hearing if you're still under pandemic conditions, or in front of an actual courtroom. Make sure you have the information to participate. For argument purposes, make sure that you're addressing the judge as your honor. Be respectful, don't argue with the court. You'll have other options for relief if you don't like what the court is saying, but it does not help you to be combative or argumentative with the judge. Just a few brief notes about hot bench versus cold bench. Hot bench is when the judge is asking you a lot of questions. You should have an argument outline which has at least bullet points for the major points you want to make before the court. If you have that argument, then even if you're interrupted, you can come back to your arguments. Make sure that you're listening to the court's questions. If you don't know the answer, it's fine to say, Your Honor, can I file a pleading? Can I explain that to you by a brief later? Is that okay? See if the court wants you to do that. If you have a question, for example, we have a commissioner that is pretty notorious for citing cases. If you don't know what that case is, ask the court to give you some details, and then once you have the court's explanation, make your argument based on what the court's explanation was, and mark your place in your argument so that you can go back to it. A cold bench is when the judge doesn't ask you any questions. If that's the case, then before you conclude your argument, just give your outline a once over, make sure that you've addressed all your points. All right, so with that, I have a Facebook page, which is Tacoma Legal Coach. My name is Beverly Allen. I'm happy to take your questions if you message my page or if you call me at 778-6376. Thank you very much.